Why would Scott Falater murder Yarmila unless he did it in his sleep?
What were the arguments from the defense on that, on why this wasn't a fair trial, why he should get a new trial, things like that?
Yeah. Ryan McPhie. I'm David Lish. We're the owners of Grand Canyon Law Group. Ryan, why don't you tell us a little bit about your background? Who are you?
Sure. So I'm a criminal defense attorney. That's what I do. It's all I do. It's all I've done for, 12 years, 13 years. And one of the owners of Grand Canyon Law Group.
Yeah. And Ryan, you and I have owned this firm together for 5 years. Coming up on our 5th anniversary. July will be 5 years. Prior to that, I worked for another defense firm. I was a prosecutor for a couple of years in Scottsdale, prosecutor for 6 years at the Maricopa County Attorney's Office. You've had your own firm, though, for a few years before we got together.
Yeah, and I had kind of a similar background, but not as long in the prosecution world. I also was at Maricopa County Attorney's Office before starting my own firm. Did that for about 6 years before we teamed up.
Yeah, and so what we do is just criminal defense. We don't do any other types of cases, family cases, personal injury cases. We don't do those. We just have a criminal defense team of lawyers and staff to focus on, that type of case. So what we wanted to do this morning was dive into a criminal case and make this kind of a series, understand a little bit about some significant Arizona cases that have passed through the years, and dig into them, talk about the legal issues that come out of them, some of the ethical issues that come out of them, and then help, the public sort of understand how we view the world from a criminal defense perspective, right?
Yeah, and the hope is that we're going to take a look at these things a little bit differently than, say, like a normal crime podcast where they sensationalize the story and talk about all of that kind of stuff. I think our focus, hopefully, is going to be more based on what did the jury hear? What was the trial like? As criminal defense attorneys, how do we see it a little bit differently? And hopefully that'll be interesting for people.
Yeah. And so, the case that we wanted to begin with this morning, it's kind of an interesting one. It's back from a number of years ago. It's what they called at the time the Sleepwalker case. The defendant was a guy named Scott Falater. And Ryan, did you want to dive into a little bit of the facts of this case?
Yeah, these ones are interesting, right? You hear the story, and like you said, a lot of people characterize this case, or it was even called, I think, the Sleepwalker case, where Scott Falater was accused of murdering his wife. The facts weren't in dispute that he'd done that. There was an eyewitness to it, and that the defense was that he was sleepwalking at the time. Sometimes kind of sounds ridiculous, crazy, right? That type of a defense. So we're going to dive into that a little bit and talk about it. I thought a good way to do it was there was a Court of Appeals decision that really just lays out the facts in what we say kind of a sterile way, right? Where you just hear facts and that gives kind of a certain reaction or impression of what the case is about, how strong it might be. And then we'll talk a little bit about whether there's some questioning that can be done on some of those assumptions.
And before we get into that, I think it's a good point to recognize that what the media presents as facts or what the world sometimes hears as supposedly the facts of the case may differ from what a jury actually hears. And I don't think people appreciate this as much as, as they should, because in sort of the sterile environment of a courtroom, there are rules of evidence and rules of procedure that prevent the jury from hearing extra facts, things that aren't considered relevant, things that aren't allowed to come in. And so a jury has a very closed picture of what the evidence in a case actually is.
Yeah, and sometimes you get that confusion by the public, right? And they take a look at a case and they say, how could a jury come up with this conclusion? Either one way or the other, saying how could they have found him not guilty or how could they have found him guilty in a particular set of facts? And that's just so interesting to me. And so hopefully we'll be able to kind of peel that back.
All right, so why don't you go ahead and dig in, and you're really reading or paraphrasing directly from the Court of Appeals opinion. And that's important because the court has to rely on exactly what the record was that was presented. So nothing extraneous, nothing that was sort of sensationalized in the media comes in. It's just what the jury heard.
So the Court of Appeal says that about 10:15 p.m. on January 16th, 1997, defendant stabbed his wife, Yarmila, victim, 44 times. He used a hunting knife that had a 5.5-inch blade. Defendant stabbed and cut the victim all over the upper part of her body, in her chest, back, head, ears, and neck. He also inflicted several defensive wounds to her hands. Defendant's next-door neighbor, Greg Coons, was about to go to sleep when his girlfriend told him that he had just heard a woman screaming. Coons went out to his backyard and heard moaning coming from defendant's backyard. Then he heard someone walk into defendant's garage. Coons went to the 6-foot-high wall that separated the 2 yards, stood on a planter made of railroad ties, and looked over. He saw a woman lying on the ground, with her head towards the house and her feet towards the swimming pool. As he watched, the woman rolled onto her left side, put her right arm over the top of her head, moved her legs a bit, then laid on her back again. Coons' initial impression was that the woman, who turned out to be the victim, was probably drunk. Coons then saw lights go on in the upstairs master bedroom and bathroom of defendant's house. He saw defendant wearing a white t-shirt walk past the bedroom window and go into the bathroom. After a few minutes, defendant turned off the upstairs light and went downstairs into the kitchen, where he appeared to be wringing his hands as if he had just washed them. Defendant then opened a sliding glass door and led to his backyard, motioned for the dog to lie down, which it did. Defendant then walked within 2 or 3 feet of the victim and looked down at her as though he was wondering what to do with her. After about 30 seconds, defendant walked back inside the house and shut the sliding glass door. Coons next saw defendant walk out of his garage, putting on canvas work gloves. Defendant walked up to the victim, stepped over her, and dragged her towards the pool. Defendant then knelt down beside the victim, pushed her into the pool, and held her head underwater. Coons then left to call 911. Police subsequently found the murder weapon, bloody jeans, gloves, boots, undergarments, and similar items inside a Tupperware container and a garbage bag that were hidden in the spare tire well of defendant's vehicle. Dr. Keene, the chief medical examiner, testified that because the stab wounds in victim's chest had bled more than those in the back, the chest wounds had probably been inflicted first. Dr. Keene agreed that the upward trajectory of the frontal wounds was consistent with the taller defendant having approached the victim from behind, reached around, and stabbed her in the chest. Dr. Keene also testified that the victim had possibly died before getting pushed into the pool, but that the facts were a little ambiguous. Because liquid of an undetermined type, possibly water, had been found in the victim's left lung and water had been found in her sinuses. Dr. Keene opined that she might have been alive when she was put in the pool. The death certificate, executed by Dr. Ann Buchholz, the pathologist who actually performed the autopsy, listed multiple stab wounds with drowning as the cause of death.
So really a very brutal act of murder. I mean, you have a large hunting knife, stabbed her 40-something times. And then what's interesting to me is, he motions to the dog to calm down or to sit down. He goes to the garage where he then hides or puts away the murder weapon and other items in a Tupperware inside the well of the trunk of the car. What would seem like a very planned and meticulous homicide, bloody and gruesome to be sure, but at least planned, right?
Right. And the interesting question, I think, there's lots of them in this case, is, sleepwalking. How did that become the defense, and how does that work? So first of all, how was that defense born? Or how did they come up with that defense? Was it just automatic? Reading through the stories from the time, this was back in 1997, so we're doing a little backwards look, and we don't have a full access to all the records as far as what evidence was presented in trial, but you take a look at it, and he hired a very experienced, a very well-known attorney, who then they got together. This attorney quickly interviewed the neighbor the witness neighbor, who apparently had changed a couple things in the story a little bit, and it was quickly brought to the attorney's attention that Mr. Falater had a history of sleepwalking. Is this a novel defense, Dave? Have you heard of this before?
Well, I mean, really, this one stands out in Arizona history as kind of the only one, right? One of the things that I thought was interesting was was Scott Falater's interview with police, because he had told them, I don't remember doing this. He claims that his first memory of anything happening, I believe, was when police got to his house. Now, this was a very, as I said earlier, violent, it caught the attention of a neighbor who was looking over the fence. His children, who were, kind of adolescents at the time, slept through the whole thing. And when Falater is interviewed by police again, he says, I don't know what happened. I don't remember.
And that's backed up by the responding officer who comes into the home and is yelling and talking to Mr. Falater, who says he was hopelessly confused about why they were there.
And so really, I think that's the genesis of the sleepwalking defense, this idea at the outset that Scott does not recall anything that just occurred. And so, as you mentioned, he hired a very experienced criminal defense attorney who then works to develop this defense. And, you said this at the outset. It kind of seems crazy to say, well, he's going to claim that he was sleepwalking at the time. And what's interesting in Arizona and really across the United States, mental health defenses can be complex, but they're also very limited. Really, in Arizona, the only mental health defense that is viable or that's allowed is insanity. And insanity is that the person does not understand the difference between right and wrong. They don't appreciate the wrongfulness of their conduct due to some mental disease or defect. Here, Mr. Falater is not claiming insanity. And so he's not claiming that he didn't know what was going on because of some mental defect. Instead, he's saying, I was asleep and my actions were not voluntary.
And how is that a defense to a criminal act?
Well, in law school, we learned that criminal acts have really two parts. There is what they call the actus reus, in other words, the physical act that is the criminal conduct. The other part of it is what they call the mens rea, or the mental state. So, think of it in a simple case like possession of marijuana, which I guess isn't a crime anymore. We'll call it possession of narcotic drugs, okay, perhaps fentanyl or some other illegal drug. You have to knowingly possess that item. So the knowingly part is the mens rea that says you have to be aware that you are possessing this item and that item is what it is, okay, methamphetamine, whatever. And then the second part, the actus reus or the conduct, is physically possessing that item, okay? So here in this homicide, Mr. Falater claimed through his attorney and actually on the stand, he ended up testifying, and we can get into that in a little bit. He ended up claiming that his actions, the fact that he stabbed his wife, apparently drowned her, at the end of that stabbing and put things away to hide that evidence, was not done voluntarily, right? I mean,
that there was no mens rea, right? Nothing in his mind that said he intended or voluntarily committed that act.
Correct. So, it wasn't a voluntary act by him. In other words, that linkage of the mens rea, the guilty mind, and the criminal act never happened. Those two things didn't come together because he was sort of unconscious at the time that he was doing this. He didn't knowingly or intentionally kill Yarmila.
It's just a fascinating thought, right? To think about that somebody could commit a clearly heinous and illegal act, but that potentially there's a defense in it because they didn't mean to, essentially.
Yeah, and so, it raises the question, how does somebody then raise this defense effectively at trial? I think his lawyer did a nice job in laying the groundwork for that. As I understand the facts, his attorney, of course, hired experts, and, we can talk about the role of experts here for just a minute. Prosecutors, defense attorneys, we all, especially in complex cases, rely on the testimony and the opinions of experts, okay? Experts in a particular field, whether they're computer experts or mental health experts or the state, they rely on their medical examiner to offer an opinion about the cause and the manner of death. Well, in this case, the defense hired a couple of experts to examine Mr. Falater's sleep habits. In fact, I think they did a study with him to study his sleep patterns. And it turns out he fit sort of this profile of somebody who has characteristics of sleepwalking, right?
Yeah, and it was really interesting to look at some of their testimony because, without getting too deep into what you get a battle of experts sometimes, right? You had the state's expert who was saying, look, these complex actions that he was taking show that he couldn't have been sleepwalking. Whereas the defense's experts were saying, no, absolutely not. We see very complex actions that people take while in their sleep. And the fact that, we didn't get too far into this, that he had changed his clothes, that he'd washed up, don't necessarily show that he, wasn't sleepwalking. And the other piece of it that we've talked about and maybe is a little tangential is to say, even if he had woken up at some point during this and it's over and she's already been murdered or killed, I guess I don't know if we'd call it murder, right? That the homicide had occurred.
She had died.
Yes, she had expired. And but then he realizes it and tries to clean up a little bit. That's not murder, right?
Yeah, and there's a couple of things that, this really is a wrestle. The state presents evidence of a brutal homicide. And their prosecutor, Juan Martinez, and we're going to talk a little bit more about Mr. Martinez in a little bit. But the prosecution presents this cruel, heinous murder. The defense presents evidence but through experts, of sleepwalking behavior. The state also presents evidence through experts saying, no, that type of behavior is not possible in a sleepwalk, or to commit or to do while somebody is sleepwalking. And you wonder, that many stab wounds, pushing her, holding her underwater, and then, hiding the evidence. Me personally, even as a defense lawyer, I find that difficult to believe. And so you have this, combating expert opinions. And really, this I think is helpful for people to understand. The jury gets to decide what the facts are in a case. They get to decide which of these experts are they going to believe and who is more credible. Now, one thing that we haven't discussed yet is, Mr. Falater, his now deceased wife, had a couple of children. They had on the outside, or apparently a pretty idyllic family setting, right? I mean,
yeah, and that's something I want to kind of touch on, is to say we haven't really talked about what the jury actually heard, right? As far as how that all came out. First, you hear the sterile facts after the trial, right? That we put out, but that's not how it came out to the jury, and that's, when we give you kind of the other side of it, it talks about, as far as some of these opinions, some of these articles that we've read, you can't just say he was sleepwalking, right? And then just come up with it later. Some people kind of get that impression that you can just kill somebody and say, I was sleepwalking, and see what the jury says. There's a lot of requirements or really hurdles that had to be overcome in order to even present this defense, right? And so I think you were getting into that a little bit. I think you made a good analogy. So in a drug possession case, right? And you say, hey, I didn't know these drugs were in my possession. That might sound, silly, right? But we see circumstances where it's in the armrest of a car that you're borrowing. Okay, That makes a little bit more sense. Those surrounding circumstances help us understand whether that mental state defense is appropriate, right? And so what were some of the surrounding details? And you were about to get into that. Number one is, what kind of guy is this guy,
Yeah.
in their background?
Yeah, and I thought that was the most interesting, is this idea that, you have, an apparently loving husband, a loving wife. He has a successful career as an engineer. The kids are doing well, and everything on the outside seems to be fine. And so what really, I think, helps the defense of sleepwalking is this idea that there's no real motive. Why would Scott Falater murder Yarmila unless he did it in his sleep?
And the other piece of that is a complete lack of history of anything like this, right?
Right.
You had his kids talking about what a kind father he was. You had everybody that knew them talked about that he was not a violent person in any way. There wasn't any strain in the marriage that anybody was aware of.
And sometimes, in these family related homicide, domestic violence homicide, you'll see a pattern of domestic violence. There'll be call outs by the police, or neighbors will say, hey, these guys were always bickering and fighting. But in this, there really was no evidence of that, at least not anything that I'm aware of, nothing that was reported in the media, nothing that came out in the case. And so out of the blue, you have this guy murdering his wife. If I'm the defense attorney, I'm going to hone in on that. I'm going to say, why on earth would this happen except that he was sleepwalking?
Exactly. And that's why you'd be able to say it, right? As opposed to what you're saying he did. And the other piece that they talked about, you can't just say he's a nice guy, is a history, rather than a lack of criminal history, an actual established history of sleepwalking and behavior like that. And they were able to present that
right.
as well.
And at the trial, the children testified about their, how he's a loving father. There's no problems in the home. There's no, fights or arguments, which I think really goes to the idea that, what motive could there be? Now, I know Juan Martinez honed in on some piece of writing that Scott had written, I think, as part of some of his examinations, that talked about this unforgivable sin. And it was really a mystery about what that truly referred to. Mr. Falater maintained that unforgivable sin that he wrote about was the murder of his wife, that he felt so awful about having physically done this. Even though he's not mentally there, he physically committed this act and, had this, he's racked with this guilt. Martinez, the prosecutor, wanted to insinuate something else. And I don't know that he ever actually had any real concrete explanation for it, other than to sort of hint at the idea that maybe one of them had been unfaithful to the other. And so that's the motive. Now, as I see it, I didn't see anything that supported that. And it's interesting that Martinez went in on that topic. I mean, he honed in on that phrase, I think, to develop a motive or create a motive that gives the jury the ability to say, this is why Falater killed Yarmila.
Yeah, and it's important, we always say, right, the state doesn't have to prove motive, but in a case like this, where that's part of the defense, to say, well, what other explanation is there? I think he had to try to come up with something. Now, the other piece that we were talking about is I think in order to make this a believable defense, you have to show some type of pattern or history of actual sleepwalking. He had his sister come in and testify that when she was, I'm not going to be exact here, but I believe she was about 15, he was about 20 years old. Shortly before actually he got married, he walked in downstairs, half dressed, and she said he was like in a trance. She reached around him to lock a door because he was fumbling with a back door to get out, and he just picked her up and tossed her across the room. So this is something that they can establish was a history. He also had multiple other events that they talked about growing up that his family would talk about that he had done. He also established, I think, through his own testimony that he had multiple occasions where he would wake up in other parts of the house that he didn't know how he got there. And obviously, the other people that were able to testify to that weren't available. So that was interesting that they could actually have a plausible or an established way to show that he had sleepwalked before. And then you talked about that the study that he had done showed that he did actually match that profile to say that he is somebody who sleepwalks.
So one thing that I think is important for people to understand, in my own practice and your own practice, look, we do trials. Criminal attorneys go to trial, I think, more often than most other practice areas. And one of the things that is really important in a criminal case is the decision about whether your client is going to testify. Under the U.S. Constitution, the Arizona Constitution, the accused has an absolute right to silence. That includes at the investigation stage with the police. They don't have to speak. They cannot be compelled to offer any sort of testimony. But that rule extends into trial. An accused does not have to testify. They have a right to remain silent. And the jury is specifically instructed, you cannot use that decision not to testify against the accused. And it's one of the most important, I think, pillars of the criminal justice system in the United States. Yet in this case, Scott decides through his attorney or with his attorney that he's going to testify. Now, I've been in that circumstance many, many times. I don't know what your position is on this, but mine is, if I can avoid having my client testify and still present my defense and increase my odds of winning in a trial, I'm going to keep my client off the stand, because I don't know what they're going to say, or I don't know how the prosecutor is going to approach cross-examination. I don't want the prosecutor to use my client to fill in any gaps in their own evidence, which is a real danger. Of the trials that I've won, many of them have come because the state fails to present sufficient evidence. And if I keep my client off the stand, it keeps the state from using my client to fill in holes. And so in a case like this, similar to like a self-defense case where the client or the defendant, usually needs to testify in order to tell their side of the story, here Falater needed to testify in order to fully present that defense of sleepwalking. Agreed?
Yes, and it is. It's very dangerous to have them testify. I remember as a prosecutor, I had a situation where we had a real problem establishing identification, which is obviously
who done it.
You got to do that, right?
Right.
And we had video, but it was kind of wild video. Couldn't really tell that the person sitting at the table was the same person in this video. She testifies, and I say, "Who's that in the video?" And she says, "That's me." Right? So that's where you really kind of get at risk of filling in those holes. But at the same time, I completely agree that, and I think more and more juries now want to hear from a defendant.
Well, of course they want to, right? I did a trial just a few weeks ago, and it was a situation where there's a felony jury trial. It's very serious charges. My client is accused of sexually abusing, a family member decades earlier. And of course the jury wants to hear from the defendant. They want to understand from their perspective what happened. Knowing ahead of time that my client likely was not going to testify, during jury selection, I had to engage in some questioning with the jury to weed out the folks that are going to hold lack of testimony from my client, that are going to hold that against him. And you'd be surprised. I really had to go in and develop that theory or that portion of our defense with the jury. And a number of jurors were removed from the trial because they just couldn't get along, couldn't capture the idea or wouldn't go along with the idea that the accused wasn't going to testify.
Right. And it's interesting. It's not that we're controlling things or manipulating the situation. That's the law. They are not allowed to hold a lack of testimony against them does it happen anyway sometimes? Yeah.
Of course.
Yeah.
And you and I and our colleagues, on the defense bar, we can do the very best that we can to try to screen out a juror or jurors who aren't going to follow the law. But I don't know what happens inside their heads. I don't know what happens in that deliberation room. And so, we do the best we can. And of course, the system isn't perfect, but you're right. That's the law. They're charged with following the law. And we just have to live with it.
Yeah, and you got to try your best in closing arguments and throughout the trial to remind them and get them to not do that. But
right,
easier said than done.
And so back to Mr. Falater. I mean, he testifies. He talks about not remembering what happened, about sort of snapping to when the officers showed up. They develop, of course, the defense theory of sleepwalking, and through him, then they're able to get history of his own behavior and other things, not just through him, the sister, through their own experts, and really the state or the defense, is able then to thoroughly develop that defense of sleepwalking, sort of with the capstone of Falater, talking about his own experience. The guy who was there, the guy who is on trial says, I don't remember this. I was asleep.
Yeah. And it's an interesting question to the public, right? Is under these circumstances, knowing that this guy, let's say we assume he was asleep and that he was sleepwalking. Does that mean you don't get convicted of murder? That
is a really interesting question, right? Setting aside what the jury's verdict was and his sentence, and then just incidentally, he was convicted, right? The jury came back, they found him guilty. Judge sentenced him to a life in prison, and he's there today. The question, more interesting question than that, I think, is what you just posed. Suppose they find him not guilty. Then is Scott Falater then on the streets? What do we do? What do we do about his sleep? Now, the law says if he's found not guilty, he walks out. There's no third option where they say, well, you're guilty, but you got to, take care of the sleepwalking issue.
Really got to address that.
Right. You really,
we can't
probably should take some pills, something, right? But that's not how this works. It's interesting. We talked earlier about the defense of insanity. Now, when somebody is found guilty except insane, meaning their defense of insanity worked, they're not set free.
And that's interesting, right? Because that's kind of under the same umbrella, sort of this type of case, but it's different. Like you said at the beginning, it's a mental defect, not a lack of voluntary action. So a little legal, but
the end result is different. So if somebody's found guilty except insane, they are ordered to the state hospital for treatment, and that may be for a significant amount of time. Exactly.
Yeah.
Scott Falater, had the jury said not guilty, Scott goes home.
Yeah. And so I did find a similar case in the 1980s. I was reading about it in Arizona, where the guy presented a sleepwalking defense. He'd stabbed his wife 30 some odd times. And in my view, at least from what I was able to see, it wasn't nearly as good a defense. And he was found not guilty and released into the public. And, he got treatment for his sleep issues, and it hasn't killed anybody yet since then. So it's very interesting.
Well, and I think that's a good point. Scott Falater was not the first person to present a sleepwalking defense. It got a lot of media attention at the time, and I think it is sort of, at least in my mind, I've known about this case forever, and it's sort of burned into my own brain as, hey, the sleepwalking guy. I think that's because of the publicity, and it got national publicity. This has been on shows like Dateline and others, and in fact, they've even recapped it. I mean, if you do an internet search, you can watch videos and interviews. You can watch interviews with Scott. You can watch interviews with his children. I mean, it got a lot of play in the media. But again, not the first sleepwalking case.
Yeah, in fact, others were found not guilty.
Right.
In Canada, I saw that there were some there and a similar defense. So, and I guess that's the question, where do you come down on that? Is if somebody is able to show enough evidence that potentially, which is kind of confusing, right? Because you're not supposed to have to show evidence, but...
Well, the burden always remains with the prosecution. right? They have to prove the charges beyond a reasonable doubt. But when you're talking about what we call an elements defense, meaning the defense is saying that the state failed to meet its burden to prove those two elements, the mens rea and the actus reus, the guilty mind and the physical act. Here it would be that the defense presents enough evidence to show that the state didn't meet its burden.
Right. Okay. So let's if we can, if you think I'm jumping ahead, let me know. But found guilty, then there's always an appeals kind of process that goes through that. We don't want to spend too much time on that, but some appeals obviously are automatically done in any type of homicide case like this. What were the arguments from the defense on that, on why this wasn't a fair trial, why he should get a new trial, things like that?
Yeah, so on the appeal side of it, it really focused on jury instructions, okay? And what jury instructions are the rules that the judge gives to the jury, the written rules on what they have to follow in order to decide the case. Here, the focus was on the idea that the defense really wanted a sleepwalking instruction of some type. Instead, the judge decided not to give any sort of special instruction, but simply the standard instructions regarding, the elements and what the state had to prove. And then the defense was simply forced to make arguments that the state had failed to meet its burden because the defense had presented sufficient evidence.
And there's always an instruction on voluntariness.
That's
right. And that's
voluntary act.
Right. And that's what they kind of come down to, is they said that was sufficient, right? That one. And because juries are instructed to compare the evidence that they saw in trial with those instructions. That's how they make their decision.
Yeah, and the juries decide what the facts are, but the judge gives them the law to frame those facts. And so on appeal, Falater argues, well, the correct instructions weren't given. The judge should have given an additional instruction. Court of Appeals doesn't accept that argument. His sentence is affirmed. He does a couple of other appeals. In fact, what you were reading from was an appeal to the federal courts on what they call a habeas corpus petition. It's a different type of appeal, but the same principle holds, that he's continuing to ask for these types of instructions, doesn't get it, and he's still in prison in Arizona today.
Should we jump a little bit? And I think we've talked about that potentially we're going to address this in a little bit more detail, maybe later on. One of the things that they also presented in that habeas corpus was that there was prosecutorial misconduct by Juan Martinez, who was the prosecutor who became pretty famous with the Jodi Arias trial. He was the prosecutor in that case, but also multiple other capital and murder trials. What was the argument there, and what, was there any legs to that argument?
Yeah, so, Martinez, as you said, has gotten a lot of attention with his, how he's handled cases in Arizona, particularly the Jodi Arias matter. He became very, very famous in that. And in fact, and we'll touch on this, but Martinez no longer is licensed. He has been disbarred by the Arizona Supreme Court. By consent, he essentially relinquished his law license. But that came as as a result of some ethics complaints that he received, a couple of major cases that were brought in front of the state bar, and ultimately he decides he's not going to contest at least the second one, and gives up his law license. So yeah, I think now is a good time to shift gears a little bit. Let's focus on prosecutorial misconduct. I was a prosecutor for years. You were a prosecutor for a time. That is you're really in a different role. So let's talk about that for a second. Okay, so we had touched on the idea that Juan Martinez was the prosecutor in the Scott Falater case. He's also been a prosecutor in a number of prominent media attention-getting homicide cases, Jodi Arias, others. One of the things that stood out to me, we're going to shift our focus now to the idea of prosecutorial misconduct, what that is. One of the things that stood out to me was the way Martinez tried to create that motive using this phrase that Falater had written of the unpardonable sin, somehow insinuating that Yarmila, or perhaps I think Yarmila, had been unfaithful, had cheated on Scott, which was potentially the motive for murder. We've talked about sort of this idyllic lifestyle that they had, the Falaters, and really no lack of apparent motive. What's your take, or what's your opinion on Martinez honing in on that phrase and sort of crafting or creating something to give a motive? How ethical is that?
Yeah, it's tough because prosecutors really are taught to create a theme, right? And to have a theme. And I think that it's also taught that it's best if you can pull it from the defendant themselves and something that they said or did. I think where, and I don't know if I'm an unbiased party on this as far as the defense and the prosecution. I think there's a line that gets drawn that if you're going to do something that's inflammatory like that, talking about insinuation of some type of cheating or issue where there's really no evidence of it, as a defense attorney, I would say, look, you can't bring that in unless you have something. Like, there has to be some type of basis or foundation. I don't think they'd have to prove it beyond a reasonable doubt or anything like that. It's not an element of this offense, but in order to raise that kind of inflammatory idea to a jury, there has to be some way to establish at least that makes sense, or that there's some evidence of it. What are your thoughts?
Yeah. So the law allows for our lawyers to make arguments that are that have a reasonable basis in the evidence, or a reasonable logical conclusion or a logical extension from that. If I were Martinez, I would say, Judge, this phrase unpardonable sin, certainly that could refer to adultery or, some other similar act. And so you got to let me present that argument. But as you said, though, there really is no factual basis for it other than the phrase by itself. Now, Martinez certainly, I think, pushed the boundaries of what should and could be argued based on that phrase. And Falater's conviction was not overturned or disturbed based on Martinez's conduct. But through the years, Mr. Martinez built himself a history that eventually came to the understanding, the knowledge, the scrutiny of the Arizona courts, through these cases that he's tried. And eventually that came back to bite him. And so, let's talk a little bit about, I think, first of all, the role of a prosecutor. Again, you were a prosecutor, I was a prosecutor. How is a prosecutor different in their role?
It is different. I think that sometimes people have their perceptions of what a defense attorney is and what a prosecutor is. And we have something, and it's not, making a judgment call on it. It's actually called an adversarial process that we have in criminal law in the United States and in Arizona, where you have a prosecutor trying to prove that somebody committed an offense, and you have a defense attorney trying to defend against that. And the prosecutor, though, has higher responsibilities, ethical duties, because in many ways they have an advantage. They have additional information. They're able to direct whether this prosecution even happens in the first place. And so, as opposed to a defense attorney who's a little bit more free to make arguments and make defenses, the prosecutor, as the representative of the state, is under duties to make sure that the way that they do it is fair and it's ethical towards the right outcome.
Right. And to be clear, all lawyers, prosecutors, no matter what arena of the law you practice in, we all have a code of ethics that we have to follow. But prosecutors have a special duty to be what they call a minister of justice. And what that means is that they have to make sure that the right outcome happens in a case. It's not a win at all costs job. Meaning, if you believe, if I were a prosecutor, okay, or back in the day when I was, if I thought or I believed that the evidence either was lacking or I didn't have sufficient proof to show that somebody was guilty, or if it turns out that, my charging that person was wrong, I have a duty to dismiss that case.
If you find information later, doesn't matter how far you are into the case, to realize that you are in the wrong or that your argument is incorrect, it is your duty to correct that as the prosecutor.
Yeah, they have to do the right thing. And where Martinez found himself, under court scrutiny is sort of this overzealous prosecutor for the state pushing the boundaries of what was allowed. In 2020, there was an opinion by the Arizona Supreme Court outlining multiple ethics complaints against Mr. Martinez, in particular in the way he argued certain cases, sort of inflaming the passions of the jury, using his role as a prosecutor to sort of push the bounds of what justice was. Ultimately, it was found that, he, in 3 of the 5 cases that were presented to the court for review as part of this ethics complaint, he was found to have violated that duty, making sort of arguments that were too much, pushing those boundaries, and doing things like putting the jury in the shoes of the accused or of the victim, and making really an emotional attack on the defendant as opposed to a factual attack. At the end of the day, in this case, though, Martinez was not, he was disciplined. He was basically censured by the bar. He wasn't put on probation. He wasn't suspended. He wasn't disbarred. Basically, he was kind of held out in public by the Supreme Court saying, hey, don't do that anymore, right?
And I don't want to misspeak. I want to make sure that that's from this opinion, but the language was really harsh against him here, where they basically said, this isn't just a couple of slip-ups by a rookie prosecutor. This has shown to be a pattern of misconduct from the highly experienced prosecutor in order to get the outcome that he wants. It was a very harshly worded, I think, sanction and very pointed to say, oh, this could have been error, it could have been just a mistake or whatever. They actually said this is a pattern of behavior from him.
Yeah, and they go to some length to explain, why his conduct crossed that line. Now, remember, there were 5 individual cases that were brought in this ethics matter. 2 of them, the bar or the Supreme Court looked at his conduct and said, he didn't cross the line. But in 3 out of the 5, they did say he pushed the boundaries with his arguments, and he should know better. He's a very experienced prosecutor. They also, though, gave him some credit because, obviously Martinez is a very capable prosecutor, very good, very experienced. They did, say that he sort of lacked any sort of selfish motive or other things. And in one instance, for instance, in the Jodi Arias matter, he was alleged to have made a very disparaging comment towards defense counsel in a bench conference. And then he quickly, in the moment, corrected himself and he apologized. The state bar and the Supreme Court acknowledged that. They said, hey, look, he took steps to remedy. He apparently was apologetic. And so I think you and I need to be very careful about, painting Martinez as sort of this evil monster. I don't think he was. I think he's a very zealous prosecutor. He took his job very seriously. And, and remember, he's prosecuting people who were accused of some very heinous things.
And I don't want to project into understanding, motives and things like that. That can be very difficult, right? But I think you and I have talked about the danger of being on that prosecutorial side for too long, where you begin to believe that everything you think is right and everything that that everybody against you is a bad guy that you're prosecuting. There are prosecutors who get into that mindset and say, look, it's my duty to make sure this person is convicted. Damn the Constitution, the rules. I'm going to do what needs to be done to get this person convicted. It's a dangerous place to get as a prosecutor.
Yeah, although in my own experience, I think most are great at their job. I give a lot of praise to prosecutors because most of them, I think, do try to do their job fairly. And the same should be said about defense lawyers. I think we get a bad rap, right? I don't know how many times people have asked me, even my own mom, how do you defend people who are guilty? Well, I defend people, I defend clients, I defend people who, maybe they're accused of doing something terrible, but they're human beings. And we live in a system where we have to defend against the power of the state. Everybody deserves a fair trial and a fair shake. And, prosecutors, I think the exception sometimes, they're overboard, right? They really try to overly punish people, overly charge. Prosecutors have tremendous power to bring criminal charges and change someone's life with the stroke of a pen. And so they need to be very careful. By the same token, we defense lawyers, we can't cross those ethical boundaries either. We have to make sure that we play by the rules. But as we mentioned at the outset, prosecutors have a heightened duty to do justice. I want to read something here from, the court's opinion about Martinez. This is related to whether, Martinez caused any harm through his comments. I think this is insightful. It says Martinez's comments to juries in Morris, Gallardo, and Lynch, too. Those are the 3 cases he was found to have committed ethical violations. And his disregard of defense counsel's sustained objections in Gallardo at least potentially caused harm to the public and the legal system. As a prosecutor, Martinez's serial improper appeals to juries to elicit sympathy for victims and fear of defendants, and his failure to comply with the court ruling jeopardized the integrity of the legal system. That Martinez's negligent conduct did not result in reversal of criminal convictions does not absolve him of ethical culpability for potential systemic injuries, meaning the way he acted in these cases, disregarding court orders and other things and appealing to the sympathies and passions of the jury, it crosses the line. It's not something that the Supreme Court is willing to condone in our system. By the same token, prosecutors have to do the right thing. Defense attorneys have to do the right thing. And Martinez here clearly stepped over that line.
And I don't know, I've been doing this a while. It seems to me that for the most part, if you are somebody who violates those things as a prosecutor, even as a judge, we've seen a lot of judges get kind of kicked off the bench. Defense attorneys that say win at all costs, kind of go against any ethical rules. It eventually catches up with those people, which I think is hopefully a good sign for the legal, legal field.
Yeah, and I think that's a fantastic point. By and large, the defense lawyers that we rub shoulders with, the prosecutors that we bump into or that we clash with, we do our jobs and we do it ethically. And those that don't are quickly identified. It's a pretty small community. I've been doing this now for close to 20 years, and I see the same people in and out. My friends that I went to law school with, some of them are judges, and many of them, have crossed over from from prosecution to defense. Some of them have been prosecutors since day one, and they're still prosecutors. And kudos to them, right? I mean, we need people in the system doing those things. But the bad actors are identified pretty easily.
Sometimes it takes quite a while, but it does happen, I think.
Yeah.
And I think that's an encouraging part of this story.
Absolutely. And we do battle and we strike blows against each other, but at the end of the day, we're doing what we believe is right for the party that we represent, whether it's the state, whether it's our own client. And, we go on to the next one.
Yeah, and we have to understand that we are both playing a vital role. I say this, two sides of the same coin. That we have to have good, fair prosecutors, and we have to have good, ethical, fair defense attorneys that treat each other, with respect, but really advocate their sides. And there's no problem, with the Juan Martinez really being an aggressive advocate. The problem is when you cross over and do the things that are inappropriate.
Yeah, and to finish the saga with Mr. Martinez, today, as we said, he is not licensed to practice law. And here's what happened. Not long after that court opinion, there was another bar complaint, a pretty extensive one, that came out saying, alleging a number of different allegations. Number one, that he had, shared confidential information, that he had engaged in some unethical conduct, that he had engaged in acts of sexual harassment with law students, law clerks who were working at the Maricopa County Attorney's Office, just a whole host of additional ethical complaints that he had engaged in unethical conduct with a juror, pretty serious allegations.
Court supporter.
This is a long complaint. In any event, and that was back in 2020. And so what happened then with Mr. Martinez is that as a lawyer, if the state bar brings ethical charges against a lawyer, you have a right to have a hearing, you have a right to contest those allegations. It's a trial.
And to be clear, they're not criminal charges. It's ethical against your license as a lawyer.
So he's not in danger of going to jail or anything criminal. But the state bar brought these charges, these ethics charges against Mr. Martinez with the possibility of some type of sanction against his license, whether that's a suspension, whether it's disbarment, something else. Rather than go through that hearing on this new batch of charges, he filed a consent agreement, which basically says, I'm giving up my license. I'm not admitting responsibility to any of those complaints. Instead, I'm walking away from the practice of law. And so then the state bar accepted his agreement to no longer be licensed, and that was the end of it. And so the career of Juan Martinez ends with a judgment of disbarment saying, he's no longer licensed to practice law.
Yeah, interesting. And so the question I have, and I don't know if you know the answer to this, that maybe some people would have out there, he was a prosecutor for 30 years or over 30 years at Maricopa County Attorney's Office. Does he still get his retirement from there?
Well, he was let go by the county attorney.
Before this even happened.
But leading up to this, he was, I think, suspended and then eventually let go. I'm not an expert in state retirement, whether somebody qualifies or not. I was in that office for about 6 years, and so I don't know all the ins and outs of that. I don't know what Mr. Martinez is up to today. I mean, if he's out there, if he sees this, I'd love to chat with him. I'd love to have a conversation with Juan Martinez and have him on the other side of the mic and really understand his perspective, because I guarantee you there are two sides to this story.
Yep.
Right? He's going to say that, he did things for a reason and, he had a perspective. And I have to respect that perspective. I probably won't agree with it. He and I are probably going to disagree, and I'm sure you would disagree with him as well about many of the things that he did. But that was him. That was his style.
Yeah.
So, all right. Any parting thoughts?
No. This is fun. This is exciting for us to be able to.
Well, hopefully this was interesting for our audience. We're going to continue with this series. We want to dive into these criminal cases in Arizona, understand them, pull out some interesting facts about them, debate them, and hopefully educate and inform and entertain a little bit those that watch us. So thank you.
Appreciate
you.
Appreciate it.